Okay. Sorry about that. So documentation within an electronic medical record is a reflection of the care we provide to our patients and is the focus in lawsuits. So here to help us understand and grasp these complex interrelated concepts is our speaker, Rachel Cartwright Van Zandt. Rachel is an innovative educator who is skilled at providing healthcare teams with effective strategies to change their thinking and improve workplace engagement. She is an expert in the healthcare industry with 30 years of healthcare experience, and she delivers more than just textbook information because she taps into her extensive medical experience. And in total, she has taught more than 21,000 health professionals. Her extensive medical experience includes being a legal nurse consultant certified and a licensed healthcare risk manager. She is a member of the National Speakers Association and Women's Speakers Association. She is a published author in peer-reviewed journals and textbooks. And in addition to owning her own medical and legal consulting business, she is completing her PhD in public policy and administration, focusing on law and policy. Rachel works with law firms and healthcare organizations, evaluating medical records for compliance with standards of care and applicable regulations. She has been an expert witness for medical negligence cases for both the plaintiff and the defense. So please help me welcome Rachel Cartwright Van Zandt.
Well, thank you very much, and it's always a pleasure to come and commune with like nurses in fellow situations. So it's always good to come here. The first slide we have up here is about our non-disclosure conflict of interest. I don't have anything that I'm promoting. Nobody's paying me to be here to promote something else along their lines. And so this is for your knowledge benefit as well, but we need to share that with you, okay? Nursing documentation pearls, avoiding perils and pitfalls. So we're going to be speaking about today in the next couple of hours to give you some really good idea about how you can evaluate the process and how you are recording the care that you have with your patients, because everyone has their own little style, and we're going to cover a lot of things that you're going to be able to grasp and apply to your own care as you record it in the medical record. Some of the objectives that we're going to be covering today are going to be looking at the purposes and uses of the medical record more from a legal perspective. Now, we're certainly going to be, looking at the pertinent issues of how we're documenting in the electronic health record, but I'm also going to add that legal perspective there on how it can be viewed if your care is being scrutinized in a legal environment. We'll be actually looking at some common pitfalls to avoid when charting in the medical record. And I'll give you many examples that you can evaluate how does that match up with the style of recording that you are currently using. Then we're going to apply strategies to reduce your personal liability exposure. And when we decrease your personal liability exposure, what happens is your credibility as a clinician increases. So that's a good thing, and that's what we're going to be looking at today as well. So things that you can apply immediately tomorrow when you start working and recording the care of the patients that you are rendering. Also discussing the implications of standards of care, because standards of care is really what everything's going to be measured against. And we're going to have a better understanding of where they come from, how to apply them, and what is all that important to me when we actually look at analyzing and reviewing care issues if there's things that don't go quite right. So let me set the stage, first of all, with identifying actually what is it that happens when a lawsuit is filed. And many of us probably have either had an opportunity to be involved in a litigation situation, but many of us probably have not, although it is getting more and more common as years go on. And many counsel will tell you that it's not, if you get involved in a litigation situation, it is when. Nurses are becoming more involved in litigation just because of the times we're living in a litigious society. So there's some things that we can do to kind of offset that, to try and keep it at an arm's length, and a lot of it has to do with documentation. So when a lawsuit actually becomes filed, there's certain things that has to happen before we get there. So a patient has to be harmed in some way. Okay, they come to a healthcare facility, they come to an environment, they go to a doctor's office, somewhere to receive care, and an injury has occurred to them. As a result of the injuries that happen to them, they themselves or their parents or their loved ones say, you know what? That shouldn't have happened to us. We deserve monetary compensation for that. And so they seek out a plaintiff's attorney in an effort to try and file a lawsuit against the provider or the entity that actually where the injury occurred. Now, as a part of that process, when they go to the plaintiff's attorney, there's going to be a nurse working with them, okay, to listen to what their complaints are, what it is that they understood happened to them. And so when they get to that point of listening to the story, the nurse working with the plaintiff's attorney is going to hear what the injured party has to say, or their parents or their loved ones that have come with them. As we're listening to their story, there are certain things that we're going to be listening for. There are 4 elements. We have duty, breach of duty, damages, and causation is what we're going to be listening for as the story unfolds. And I'm going to tell you in just a minute what those actually mean, okay? So as we're listening, the nurse is going to be interpreting that situation with the attorney to say, you know what? We may have something here. There's no way that that would have ever happened. Why? Because we know the inner workings of a hospital. We kind of know what's possible and what is just like way out there. And so when we're listening to them explain why they feel injury has occurred to their loved one, and we hear these 4 elements come up, then we're going to make a recommendation to the attorney, and he's going to say, you know what, I think we need to look at this farther. So what are those 4 elements? We have duty, breach of duty, damages, and causation. What is duty? Duty is simply this. We as healthcare providers all have the duty to provide quality of care to all the patients we take care of. We have a duty to do that. Regardless of the venue, regardless of the age of our patient, we all have a duty to provide the best care that we possibly can. Breach of duty is simply this. Either you've done something that you shouldn't have done, or you didn't do something that you should have done. And that's essentially breach of duty. So we have duty, breach of duty, and then you have damages. Damages are either physical damages, psychological or emotional damages, and financial damages, or sometimes a combination of the above. The last prong, which is causation, is oftentimes the most difficult piece that this plaintiff's attorney has to be able to prove, because causation is this. He has to be able to prove that what the nurses did or didn't do caused the injuries. So let me give you an example of what that might sound like. If I told you that a nurse administered 10 milliequivalents of potassium IV push to this 6 or 7 month old, and a couple minutes later he went into life-threatening dysrhythmias and died, you'd probably say, well, no duh, what'd you expect, right? I mean, if you give any kind of potassium bolus to somebody, it's going to cause problems. Okay? You should be able to foresee that me administering that dosage of medication to that infant is going to cause heart problems. You know that because you've been trained at that, and we do not give that kind of a medication. You drip in a small volume amount. Even with adult patients, you don't do that. So there is a certain element of causation in there that we as nurses, because we're trained in what we're doing, needs to be able to foresee some of the actions and therefore the consequences of our actions or inactions. So if we feel that there are these 4 elements can be met, then the attorney is going to say, you know what, let's go ahead and get a copy of the medical records from the facility where the injury occurred. So a copy of the medical records are going to be sent over to the plaintiff's office. The nurse working with him is going to begin to review those medical records and compare it to the story that was heard in the office. Now, why is that important? Because many times the patient's perception of the care that they received is not necessarily what they got. And we're going to rely on those medical records in order to determine what care was provided. So what are we relying upon? Your documentation, the entries that nurses put into the medical record that represents the care that was rendered.